Hello, I'm Dan Kaufman, a partner with the law firm of Michael Best and Friedrich in Chicago, and I handle employee matters for employers, and a large part of that practice is representing manufacturers in all kinds of matters, answering their questions on a day-to-day basis, and handling lawsuits that relate to employment and other issues when they arise. In the work that we do with manufacturers, we have a strong sense of how much time, energy, and resources you spend to maintain and build your businesses. And we also know how important it is to protect that investment. We're going to talk briefly about some things you can do related to your employees, your confidential information, your trade secrets, and your customers to help protect that investment so you can protect your interests and continue to maintain and grow your businesses, and also to help ensure that your employees who leave you and your competitors engage in fair competition. We'll focus mainly on what you do when you hire employees and what you do when your employees exit and leave your employment, because the steps you take are critical to protecting your business interests, both when employees join you and when they leave. There's a public policy that says that employees are generally free to go work where they want and to do what they want, but there are some restrictions on that public policy. The laws, both federal and state laws, restrict their ability to engage in certain activities, such as the way in which they use computers. And there also can be agreements that restrict the activities of employees. And you may be familiar with restrictive covenants. Some people know these as non-compete agreements. Some people know them as unfair competition agreements. But there are multiple laws and can be multiple types of agreements that cover employees' activities both during their employment and when they leave their employment with you. These restrictive covenants can come in many different forms. They can include a provision that restricts their ability to use and disclose your confidential information and trade secrets. They can include a provision that restricts their ability to solicit your customers when they leave your employment or solicit your employees. And they also can include a literal non-compete agreement, which says that for a certain period of time after they leave your employment, they cannot work for a competitor or engage in any competitive activities. Some of these agreements also relate to the ownership of intellectual property that you have as a business and you've built up and maintain. Let's focus on these restrictive covenant agreements because these can be critical to protecting your confidential information, trade secrets, your customer relationships, and your relationships with your employees. There really are two myths about these non-compete agreements, I'll call them. One, some people think that they always can be enforced by the courts, and on the other hand, some people think they never can be enforced by the courts. And the reality is somewhere in the middle. It depends upon the specific facts and circumstances and the judges and also the state law that applies to determine whether these agreements are enforceable. They are very state specific. These agreements are different than an ordinary contract. They restrict an employee's activities, and remember we talked about the public policy that says employees should be able to go ahead and earn a living the way they want to. These agreements restrict an employee's ability to do that, and therefore courts require a specific protectable interest that the employer is trying to achieve to have these agreements in place and to enforce them. In Illinois, for example, one such protectable interest is the employer's interest in maintaining its long-standing relationships with its customers. Another protectable interest is the employer's need to protect its confidential information and trade secrets. A recent Illinois case, almost 2 years ago, changed the landscape on this and said that there could be other protectable interests in Illinois beyond the need to maintain long-standing relationships with customers or the need to protect confidential information and trade secrets. So states vary in terms of the types of protectable interests that they'll allow employers to try to satisfy by having employees enter into these restrictive covenant agreements. Another key factor that courts look to when they determine whether to enforce these restrictive covenants that you would have with your employees is the context in which the agreement was entered into. Was the agreement entered into as part of a transaction where you acquired another company and therefore acquired employees from that company, and in conjunction with that transaction had the employees enter into a restrictive covenant agreement? So it was entered into in connection with a sale or acquisition of a business. Or more typically, was the agreement entered into when the employees joined you as employees? Very often, these restrictive covenants will be a condition of employment. you say to the employee, along with the other terms of the offer, if you come join us, one of the conditions of your employment will be that you enter into a restrictive covenant agreement. Courts also look at how reasonable these agreements are, because remember, they restrict an employee's ability to engage in certain activities. So courts look at the duration of the agreement. Is the agreement prohibiting someone, for example, from going to work for a competitor for 2 years after they leave you, or for 5 years after they leave your employment? Are the agreements broad in scope? Does it prohibit an employee from soliciting all the customers they worked with when they worked for you? Or did this agreement prohibit the employee from soliciting any competitors within the entire United States? How broad is the scope? Courts like the agreements to be as narrowly tailored as possible to satisfy and achieve the protectable interests of the employer. An important point in drafting these agreements is to make them as reasonable and narrowly drafted as possible, because that will make courts more apt to enforce them. One key question is to look at what state's law will apply to these agreements. One common mistake is for manufacturers or other employers to not pay attention to this issue. For example, let's say you have facilities in multiple states, and therefore you have employees working in multiple states. The laws that apply to restrictive covenants vary dramatically. Some states do not even allow a literal non-compete agreement. Other states severely restrict the terms of such an agreement. So it's a very important strategic issue to pay attention to determine which state's law you want to apply to the restrictive covenants you have, because that will help determine how capable they are of being enforced by courts. Another key issue is the consideration that's provided to these employees when they enter into restrictive covenant agreements. What do we mean by consideration? It's a legal term, and what we mean is that when employees enter into restrictive covenants, they're giving up certain rights. Their rights to engage in certain activities after they leave your employment. The courts and the laws provide that in exchange for giving up those rights, the employees must receive something in addition to what they otherwise would be receiving from you, some additional consideration. This is a very important point. In fact, in Illinois, there was a very recent case in June of this year that changed the landscape regarding consideration. It said that if an employee does not work for you for 2 years, in other words, if they leave your employment in fewer than 2 years, it's not deemed to be sufficient consideration that they had continued employment with you. As a result, it's very important to look at this issue, and when you hire employees and have them enter into restrictive covenant agreements, to try to assign and identify separate additional consideration that the employees are receiving in exchange for giving up their rights when they enter into restrictive covenant agreements. Another key way in which states vary in terms of restrictive covenant agreements is whether they will narrow the scope of the agreements if they're overbroad. So, for example, if the agreement is in place for 5 years and the court thinks that it's too long, will the court try to reduce that time period to 2 years? Or will the court say that 5 years is too long and therefore the restrictive covenant agreement is unenforceable? Some states, like Illinois, will reform or narrow their agreements or engage in what is known as blue penciling. And that's another key factor to look at when you're trying to determine what state's law you would like to apply to these agreements, because some states will blue pencil the agreements, or at least can think of blue penciling the agreements. They may not have to, they may not do so, but at least it's an option in some states. And that's another key factor to pay attention to determining what state's law applies to these restrictive covenant agreements. Restrictive covenant agreements are critical for protecting your confidential information, trade secrets, and your relationships with your customers, and even your relationships with your employees. How you handle the situation that arises when an employee says that they are going to leave your employment, in other words, the exit interview, and the steps you take after an employee announces that they are going to leave, is also critical. You should have in place a very specific checklist of items that you want to cover with the employee during the exit interview. For example, you should talk to the employee about returning all company property, including company equipment, including laptops or other electronic storage devices. You also should remind the employee of the importance of not taking any confidential information or trade secrets or any documents from you, the employer. You should emphasize how significant that is, and that if you find that there is any violation of that policy, that you will take whatever action is appropriate. It's also important to remind employees of any restrictive covenants that they have entered into, and also give them a copy of such agreements, and then emphasize how important it is that they comply with those agreements. It's important to deliver these messages during the exit interview very clearly and very consistently, and therefore it's important to monitor and control who delivers those messages. You want to ensure that whoever is delivering those messages emphasizes how important it is for the employee not to use any confidential information or trade secrets of your business, and how important it is for the employee to comply with any restrictive covenants that they've entered into with you. We have seen many occasions where employees, before they are leaving an employment, will either intentionally or even unintentionally transfer information and data that includes confidential information and trade secrets of the employer. Sometimes they'll transfer it to their own storage devices, and sometimes employees will claim that they didn't realize that they were taking confidential information. It's very important for you to protect against any such transfers of information and to remind employees how important it is to comply with their obligations. If you suspect that employees have not complied with their obligations, if you suspect that they've engaged in any activity that is inappropriate, then often we'll send a letter to the employee and sometimes to their new employer to remind them of the importance of complying with the obligations, and also to warn them that we'll take whatever action is appropriate, including legal action if necessary, to enforce the obligations for them not to use any confidential information or trade secrets of the employer, or to make sure that they comply with the obligations under the restrictive covenant agreements. We've been talking about what happens during the exit interview when employees leave you. The steps you take when employees come in, when you hire them, are also critical to protecting your investment in your confidential information, your trade secrets, your customers, and your employees as well. It's important to protect your business interests with your process that you apply when you hire employees. Part of that process is to warn employees not to bring with them from their former employer any confidential information or trade secrets. We have found that it is impossible to be too blunt in this warning. We've also found that it's important to repeat this warning to employees, because we have seen occasions where employees, though they have been warned, nevertheless, for whatever reason, bring confidential information and trade secrets from their former employer, and therefore end up in a dispute with their former employer, and then you as the employer, the manufacturer, can become implicated in that dispute and face all kinds of time, energy, and legal expense which you otherwise could avoid. It's also important for your supervisors to understand that they should not allow any employees to bring or use any confidential information from their former employer, and to make you aware of any violations of that. We also find that it's very helpful to put in writing, it could be in the offer letter or some other writing to the prospective employee, that they are not to bring with them any confidential information, trade secrets, or property from their former employer. That's critical as well. It's also important to find out what, if any, restrictive covenants that employee has entered into with their former employer. Do they have a confidentiality agreement? Do they have a provision that prohibits them from soliciting the customers of the former employer or the employees of their former employer? Or do they have a restrictive covenant that prohibits them from working for a competitor? You need to know these things before you make the decision to hire that employee, because obviously they need to be able to engage in the activities that you want them to engage in to be a productive employee when you bring them on board. It's also important to get a copy of those agreements so you can examine them yourselves to determine what provisions the employee is bound by, so that you can make sure that they don't violate the agreement and you don't become implicated in any violation of any agreement as well. As you can see, there are important steps that you can take as a manufacturer related to your employees, both when they are hired and both when they exit, that can be critical to protecting your investment in your business and your ability to grow your business. As a result, we recommend that you conduct an audit with the assistance of counsel. What would that audit entail? It would entail looking at what policies you have in place to protect your confidential information and trade secrets. For example, do you have a policy in place that emphasizes the importance of confidentiality? Do you have a computer use policy that emphasizes what is a proper and what's an improper use of your computers and your storage devices? As part of that policy, it is critical to inform employees that they should have no expectation of privacy when they use computers that you have provided, that is critical. It's also important that you determine whether you have appropriate restrictive covenant agreements in place. First of all, do you have restrictive covenants? And if not, why don't you have them? And if you do have them, it's important to look at them and make sure that they are well drafted. Have they been updated in the last year or two? Are they reasonably drafted to try to achieve and satisfy the protectable interests in a way that courts are more apt to enforce, or are they seeking too much of a restriction on employees' activities and therefore less capable of being enforced? It's also important to train your supervisors and managers to understand the policies that are in place and to be able to help monitor and ensure compliance with the policies and the restricted covenant agreements that you might have in place. These proactive steps that you can take are critical to helping to ensure that you protect your business interests, including your confidential information and trade secrets, your customer relationships that you've worked so hard and invested so much to build up and maintain, and your relationships with your employees. You've also invested a tremendous amount to help train them and make them productive employees. Taking these proactive steps on the front end can save you a tremendous time, expense, and frustration on the back end. Therefore, we recommend that you conduct this audit and take these proactive steps so that you can continue to invest in your businesses, to maintain your businesses, and to grow them and protect your business interests, and to help ensure that your businesses are as productive as they can be and that your employees and your competitors engage in fair competition. Thank you.